going to do it. He can either plead or we'll give you the hearing right now. The witness is here, I see in the back. She can testify. You can cross-examine. He can testify. He can remain silent, whatever you choose.
Well, I appreciate that, Judge. And he'd like a hearing. And
come on up here, ma'am. All right, good enough. No problem.
Well, I mean, it just, my concern is Your Honor, in a sense, prosecuting.
I'm not prosecuting. I'm going to ask this witness to tell me what happened. I already heard from an officer. She either lied to him, in which case she's going to have a big problem with me.
No, there's not a lie. There's no lie.
Okay, state your name, ma'am.
Kayla Dukla.
Raise your right hand. You solemnly swear or affirm under penalties of perjury the testimony you will give in these proceedings will be the whole truth to help you God.
Yes.
Have a seat.
Your Honor?
Yes, sir.
If I may, I do have a little bit of information that just came to light since we've been here at court to add to this that I'd like to share with you, so you're aware.
Mr. Crane, you can have a seat, sir. Sure.
Since I entered the courtroom, the victim advocate wanted to talk to me along with the victim. It was brought to my attention that the victim received a phone call at 1:46 since she was here at the courthouse.
No way.
This is what's reported to me, Your Honor. It was from a phone number other than the defendant, but it was the defendant's voice recognized by the victim that said one word, the word leave.
All right. You can have a seat right there.
Thanks.
Tell me your name again.
Kayla Dukla.
All right. So you were in court on Tuesday, right?
Yes.
We had a hearing regarding a possible violation of the no contact provision, correct?
Yes.
Have you had any contact at all with Mr. Crane since that date? And I'm talking about since he was in court and you were in court with me and the prosecutor and Mr. McCarty and the officer in charge on Tuesday.
I haven't had contact with him, but he tried to get contact with me.
Tell me what happened.
I went to turn my phone on to check if in the
Nice
morning,
and loud for me. They have to hear you too.
to check if my daughter's dentist called me back because she had a dentist appointment that I found out on February 21st. And when I turned the phone on to look, there was a text message from Tuesday at 6:06 saying, "What are you doing?"
AM or PM?
PM.
And do you know what number that text was from?
Stevens.
Are you certain of that?
100%.
And what did it say exactly?
What you doing?
Do you have your phone?
It's here.
You still have the message?
Yes. Can I get it and show you?
Yes.
Can I bring it to you?
No, you just stay there for a second.
Thank you.
And you're telling me that was at 6:06, correct?
Yeah, 6:06 PM on Tuesday.
In the exact words were, what are you doing?
What you doing?
What you doing?
Mm-hmm.
WHATCHA.
And then doing, DOIN.
Did you have any other contact?
No, I didn't answer it. I did what you told me to do, which was contact. I tried contacting the court and got a hold of Laura. I contacted Rachel, and then I went to the Trenton Police Department and made the report.
Did he, to your knowledge, did he attempt to contact you in any other form or fashion?
Today, when I was sitting in the courtroom.
What time was that?
This was at 1:40.
What phone number did that call come in from?
734-508-2766.
Did you answer that phone call?
This phone does not let you answer on just the speaker, so you have to put it on, the loudspeaker, and I had Anna Duklo answer it because I was nervous. No one's been calling this phone except the court. So I had her answer it, and blank full day, Stephen's words, leave.
Is there any question in your mind but that it was his voice?
No.
And this happened at what time?
At 1:40.
Give me that phone number again. Read that into the record, that phone number.
734-508-2766.
Did you, when the person told you to leave on the other end, who you're identifying as the defendant, Stephen Crane, did you respond in any form or
It
fashion?
hung up the moment after it said leave. It just
Where were
hung-
you sitting at the time?
I was sitting in one of the little rooms outside, right next to a vending machine.
Next to what?
It's like the room next to the vending machine out
Okay.
there. I was already in the courtroom, like already in the court.
Any questions, Mr. McCarty?
Oh, yes, certainly. Ma'am, you testified that there was a text sent to you at 6:06 PM this past Tuesday saying, "What you doing?"
Yes.
And what was the most recent text before that one?
Mm. Sir, I went to text him on Monday, January 23rd at 7:40, and
Okay.
it didn't go through.
So that Monday, January 23rd was the morning of the alleged incident, correct?
Yes,
In fact, roughly a half hour or so before the alleged incident, correct?
yeah,
So between Monday, January 23rd, and when we were in court on Tuesday, there was absolutely no text whatsoever
until 6:06.
until 6:06. What you
After
doing?
court.
Okay,
What
I
you
understand that. Okay. And if you look in your history as it relates to texting with Mr. Crane, your recent history, it goes from blue to green to green to blue to blue to green. Can you explain to the court what that's all about?
Stephen has full control over this phone. And when it's not on a Wi-Fi, it will show up green and it will not go through. So that means the text I sent him January 23rd never went through.
Okay. And you have also a capacity or capability anyways to block him.
And he's not.
Okay. And so the fact that he's not blocked, at least evidences there was no attempts to contact you between January 23rd, before charges were ever even filed, and Tuesday, correct?
Except at the school.
Well, and then that wasn't a text, ma'am.
No, but that was an
Okay.
attempt.
I'm sorry?
That was an attempt in my form of finding me.
Well, it's certainly no secret where you were. I mean, you go to the school every day, right? As
Yeah.
this, as this
As the
is.
mother of my child.
Right,
yes.
okay. Okay, so going back to 1:40 this afternoon, you say that call came in? Or
Yes.
1:46?
140.
1:40, okay. And you lost me a little bit about your testimony. How, did you answer that call?
This phone, the speaker doesn't work, so it has to be on speakerphone.
Okay,
Anna answered it on speakerphone inside of that little room.
okay, Anna being the victim's advocate?
No, as a
Okay.
witness,
Okay. A witness in this
Well,
case?
if she needs to be, yes.
Which I
She's the one that answered the phone when that number came through.
is Anna Sophie's aunt?
Yes,
So she's a listed witness in this case.
yes,
Judge,
Wait, you gotta keep your voice up.
can we
yes.
sequester that witness, Judge, if she's,
Sure,
thank
I'll
you.
be happy to order that. No, sequestered. You're gonna have to have a seat out in the hall, man. Let me clarify one thing. You said 508-2766. What were the first numbers? The area code.
734?
Okay, I just wanted to be sure.
Okay, so because your phone has a certain malfunction, you have to put it on speaker to hear the caller on the other end.
Yes,
Okay, and when that happened, you overheard somebody say leave.
and yes, and then it directly hung up. They did.
Okay, and it's your testimony that you recognize that as being Steve's voice.
Yes,
Okay. So it's, you attribute Steve to be the caller behind the 734-508-2766 number.
yes.
Do you know where Steve was at 1:40?
No, I was in a room.
Would it surprise you to learn that he was in my vehicle in the parking lot?
No,
That wouldn't surprise you.
I don't know where he would be.
You ever sent anybody a text by accident or have an unintended recipient?
No.
No, you've never done that? Never meant to text one person and then accidentally text another?
No.
Okay, thank you. No further witness, or no further questions of this witness.
And there's no question in your mind, but that was Mr. Crane. This is really important.
Yes,
I'm talking about the phone call this afternoon.
yes, I believe it was him. His voice, just the direct words of leave and then hung up. Like there couldn't even be a word said after he said leave, and it was just hung up.
All right. You can, unless you have another question, you can step down. Do you have any other questions? You can have a
Thank you.
seat. Do you want to call somebody?
I do, Mr. Crane.
Okay.
Get your phone.
All right, recalling Stephen Crane, or Stephen Michael Crane. Mr. Bologna, 1 second when I'm done here, okay? Let's get the witness back in here. Can you get the witness, please? Well, actually, she's already done. I'm sorry. Get the detective. Mr. Crane, come on up here. I'm going to swear you in. Raise your right hand. You solemnly swear affirm under penalties of perjury. The testimony you'll give in these proceedings will be the whole truth, so help you God.
Yes, Your Honor.
Mr. Have a seat. Can you just wait 1 second? I at least want the detective in here. All right, so now I have Detective Cavazos. You can go ahead and proceed, Mr. McCarty.
Thank you, Judge. Mr. Crane, can you say your name for the record?
Stephen Michael Crane.
Mr. Crane, I want to bring focus your attention to the circumstances on Tuesday of this week, that being February 14th.
Yes,
Do you
sir.
recall that day?
Yes, sir.
You recall being in court that morning?
100% I do, sir.
Okay, do you recall having a bond violation hearing relative to whether or not you saw the complaining witness in this case and smiled and waved at her?
Yes, sir.
Okay. And
to the
you
court.
understood the court?
Sir.
Listen. You're not going to help yourself if you don't just answer his questions.
Yes, sir. Yes, sir.
Okay?
Yes, sir.
Thank you, Judge. You heard the judge's ruling in that regard.
Yes, Your Honor. Yes, sir.
That, I mean, to paraphrase it quite a bit, if you so much as like fart in her direction, you're going to jail.
Yes, sir.
You understood that?
Yes, sir.
Okay, what'd you do later on that afternoon?
I left court. When I left court, I went to work, got out of work. I got home to my mother's house at about 5:50, 5:55-ish.
Okay, when you got to your mother's house, what did you learn?
I found out that my youngest, my 7-year-old, had 101.5 fever, and my 12-year-old had a massive ear problem, ear infection, earache.
Okay, and your oldest daughter, what is her name?
Kylie Crane.
And Kylie's 11?
12.
12? And your younger daughter is?
Kristen.
Kristen, how old's Kristen?
7.
Does Kylie have an iPhone, an Android, or none of the above?
iPhone, sir.
And how about Kristen?
An Android, sir.
Okay. And where were you when you learned of their illness, for lack of a better term?
When I came home, as soon as I walked in the door, when I got to my mother, she had let me know. So I walked in to see my daughters, and Kristen was laying down sleeping still, and Kylie was laying in a dark room. And then I went downstairs, sir.
Okay. So you learned of their situation a little before 6 p.m.,
Yes,
correct?
sir.
Okay. And then you went down in the basement.
Yeah, to get my work clothes off.
Okay.
Yes, sir.
And at some point, did you text either one of your daughters regarding whatever was on your mind?
Yes, sir.
And who did you text?
At first, it was Kristen asking what she was doing upstairs.
Okay. And do you recall exactly what your text was?
Yes, sir.
And what was it?
To Kristen, it was what you doing upstairs. And then I believe it was you have to wake up, because she was laying down and I didn't want her to sleep through the evening.
Well, would it refresh your recollection if you were to look at your phone and see exactly what you texted and when?
Yes, sir.
May I approach the witness, Judge?
Sure.
And what did you text Kristen on Tuesday?
Oh, what you doing upstairs? You need to come. You need to get up, sweetheart.
Okay, and what time did you text Kristen that? The
6:08.
Okay, so at 6:08, you tested what you doing upstairs,
Yes, sir.
okay? And then when was the next text rather?
Counsel, wait a minute.
6:11.
Slow down, 1 second. I just noticed the victim back in here with the victim's advocate. I just want to be clear, you only wanted the other person out, right? Or not?
Well, no, I think they both should be.
Well, I don't disagree. You're gonna have to go out. I'm sorry. Go ahead, you're out.
Oh, thank you, Judge. So at 6:08 PM, you texted Kristen. How do you spell Kristen?
Kristen.
How do you spell Kylie?
Kyllee.
How do you spell Kayla?
Kayla.
Okay. So at 6:08, you texted your daughter Kristen. Let me just get it. What you doing upstairs? And what you was WATCHA, doing upstairs, correct?
Yes, sir.
And then 3 minutes, you didn't get a response to that?
No, sir.
3 minutes later, you texted, you need to get up, sweetheart.
Yes, sir.
Okay. Now, did you also text your mother as it relates to that particular time period when you didn't get a response from Kristen and she was sick?
Yes, sir.
Did that concern you?
Yes, sir.
What did you text your mom and when?
I believe it was around 6:11.
Let's not believe. Look at your phone
Yes,
and
sir.
tell me when you texted your mom.
I texted my mom at. Sorry, sir. I texted her at 6:11. Is Kristen up?
Okay. And your mom replied when?
At 6:12 and said, yep.
Okay.
And then I wrote at 6:12 also, I was gonna come up to wake her up. Sorry.
Okay. So at least by then you understood whatever you were inquiring about Kristen and whether she was up, she had to get up. You were satisfied in your mind that that
Yes, sir.
situation was taken care of. Now, I want to take your attention back to 6:06.
Yes, sir.
2 minutes before you tested Kristen, what you doing upstairs, you texted what you doing to Kayla, didn't you?
I'm actually, yes, sir.
Did you tell the judge the circumstances of how you texted Kayla? You haven't texted with her since January 22nd, how all of a sudden after court you texted what you doing?
Your Honor, excuse me. I was very shook and distraught with court. I went to work. I seen my daughters. They were sick. I went in, excuse me. I went in my phone. I hit K. I was trying to text my daughter. I realized I wrote what you, and I seen doing. I realized it went blue. So, and I seen it wasn't Kristen. I honestly tried to hit X to erase the message and I hit return. It sent the message. I immediately freaked out, went into my phone, tried to delete the message thinking that it wouldn't send because it did not say delivered. And then that's when I proceeded to text my daughter to make sure my kids were okay. I thought I caught it in time.
Okay, so you screwed up at 6:06.
Wait a minute, I'm not quite understanding though. You went to text your daughter.
Yes, sir.
You saw that you accidentally texted Kate.
Well, as I was texting her,
Am I right or not? I want to understand.
well, after I wrote what you doing, I realized that it was Kayla and not Kristen.
Okay.
And I tried, if you look on the iPhone, so where the X is, there's a blue bump below it. I instantly started shaking because I realized I was not Kayla. And I promised to the court, I would try to hit X. And I sent it on accident. And then I went into my phone trying to stop it because it did not show delivered. So I thought I was still blocked like I had been on the phone. I did not know I was even unblocked. I tried to erase it to stop the message from going, Your Honor. I did not intentionally. I was more worried about my kids and I was shook. Your Honor, I heard what you said loud and clear. I have full custody of both my daughters and I was not trying to make you look stupid or anything. I did not mean to disrespect the court. It was 100% accident because my kids had 101.5 fever. She was laying down and it was just a very bad day, sir.
Sir, and if you were to give your phone to this detective right now, would you be okay with him doing a forensic analysis of
He
that
can
phone?
have my phone,
You
sir.
can dump it right this afternoon
Right
and
now.
find out
100%.
what exactly you did in that regard.
100%.
So you sent a text to Kayla, correct?
Yes, sir.
You didn't mean to.
No, sir.
Okay.
I have too much to lose right now. I would not disrespect you, Your Honor. I promise you.
It's
Okay,
not a question of disrespecting me.
No, I
It's not
understand, Your
about
Honor.
me.
Well, I know I
It's
didn't.
not-
I
It has
just
nothing to do with it.
no. I meant or to even contact her. Is what I meant,
but
sir.
point well taken. Again, aside from any respect, you did not intend
Not
to
one bit
contact
did I.
Kayla. In fact, your intention was to the absolute contrary,
I
not to have
promise.
anything to do with her. Okay,
100%.
I'd like to draw your attention to the circumstances of this afternoon. Okay, you and I were speaking by phone as I was heading to this court from my location in Holland, correct?
Yes, sir.
And I told you my estimated arrival time,
Yes,
correct?
sir.
And when I pulled up, I had you come in my vehicle, correct?
Yes, sir.
And we discussed how it is that when you went to text somebody with a starting
Counsel,
initial.
Listen, I know there's no prosecutor here, but still, you can kind of not lead quite as much.
Okay.
Okay?
So we discussed the allegation of an unintended recipient of a text,
Yes, sir.
letters with a K, correct?
Yes, sir.
And using your phone, we showed how you could go to text John, but hit me instead.
Counsel, honestly, you're leading like.
Okay,
crazy. It's
So
not-
you sent me a text from your phone in my car?
That's still leading.
Okay, what did you do in my car?
When you pulled up, sir, it shows on camera, you pulled up next to me and my mother. I got in your car. We started discussing. There's text right here that you texted from my phone at 1:39 saying, "Hey, John," just to show it go through your phone so you can understand the green and the blue, or yes, the green and the blue matter of the text messages.
And how somebody could mistake John for Jeff or Jay.
Yes, sir.
And that is at what time?
1:39, sir.
Okay, so your phone says 1:39, and my phone would say 1:39.
Yes,
And
sir.
supposedly a minute later, you called Kayla?
Counsel, come on.
Well,
I know.
okay, so you were in my car for how long?
Roughly 5 minutes, and then we're on camera coming in,
Okay,
sir.
so whatever the camera shows out there as to when we pulled up and when we entered the court was how long you were in my car, aside from the time that you texted me at 1:39.
Yes, sir.
Okay. You didn't cause anybody to call Kayla. You didn't call Kayla.
No, sir.
In fact, if you look at your phone, there's not going to be any phone calls since the time you were in my vehicle.
No, sir.
Okay, I have nothing further.
Do you know who's the owner of the phone by any chance? I'm just asking.
No, sir, I do not.
Listen, you haven't even let me finish.
Oh,
my
I'm sorry.
question. Of 734-508-2766. Do you know?
No, sir, I do not.
Are you sure?
I use number. I do not recall anybody with that. I can look in my phone contacts, but I do not know that number. No, sir. I would never have anybody call either,
You're
sir.
telling us that you did not call Kayla and say leave.
No, sir, I did not.
Do you know who did?
No, sir, I do not.
Your Honor, at the,
They'll get a call you as a witness, but you could probably do it right here.
yeah,
No, I want him to be a witness. I want him to be a witness.
Okay, well, I have no further questions. If Your Honor has.
No, I don't have any other
We
questions.
can recall or whatever.
You can have a seat. Do you have any other questions?
No.
You want to come on?
sure.
Raise your right hand. You solemnly swear affirm the penalties of perjury, the testimony you give in these proceedings will be the whole truth, yourself, you got.
I do.
I have a good mind to call that phone number right now. I might just do that.
Yeah, please do.
I will. Go ahead and tell it.
Your Honor, at the defense's request, I looked into that phone number, contacted one of the other detectives at the police department. We put it in our investigative tool to find out where the number came from. The number is registered as a bandwidth number, which in my experience, and training and experience, is commonly used to masquerade. These are unregistered numbers that people can grab the number and masquerade that the number is actually coming from
A
a different device. It's not attached to a device.
So somebody can use that to disguise the fact that
Absolutely.
they're calling from, they're the one calling even though it's not from their phone.
Absolutely.
Well, if I may, Judge, so it would, let's assume for the moment that Steve used this phone to call her, it would, instead of showing up Steve's number, it would show up this masking number, correct?
I can't say that that device would record, would depict that a phone call was placed from that using a bandwidth number. I don't have the expertise to say that.
Well, you can certainly tell whether a phone call was placed from this phone.
Absolutely not.
No. Whether a call was made at 1:40 this afternoon from this phone.
I cannot.
Well, you might not be able to determine whether it was from 734-508-2766, but you can tell whether a phone call was placed.
No, I cannot.
Okay, so you don't have the expertise, or it's impossible?
I'm saying that I don't have the expertise.
You know where Mr. Crane was this afternoon at 1:40?
I do not.
Okay, so you don't have any ideas whether he was sitting in my car?
I don't.
Is that parking lot surveilled?
I believe so.
Would you care to look at the surveillance tape and determine when he entered my car and when he exited my car?
I would look at it if that's what the judge would like me to do.
Well, I think it's pretty important if the suggestion is that my client made a phone call and told the complaining witness to leave. Now, I think that's a crime. That's not just a bond violation. This is a witness intimidation. That's a crime. And lying about that.
I know, but finish your question.
Okay. So if we could take a break in this hearing, you could go and resort and look at the cameras and find out when he got in my car, when he got in my car, when we both came into this courthouse.
I believe that it would say that. I don't know for sure. But even if he was in your car, that wouldn't tell me whether he placed the call or not.
Unless I took the stand and testified as an officer of the court as to what happened in my vehicle. Judge, you know, we're so far afield now on the realm and the cusp of perjury that I think that this is vitally important. And I'm willing to have this detective do whatever is necessary for as long as necessary to determine when Mr. Crane was in my vehicle and for how long and when we exited. And I will testify as to what took place in that vehicle. The suggestion that I suborned a crime, that I someone who was a party to it.
Suggesting that you suborned perjury or suborned any type of, were a conspirator to commit a crime, obstruction of justice, intimidation of a witness, whatever you want to call it.
Okay, well, I appreciate
Suggested
that. Okay, I appreciate that.
So,
But,
well, I mean, come on, you didn't.
well, it's very, you know.
Wait a second. Do you have any other questions?
No, I don't.
Do you have anything else?
I don't, Your Honor.
Go get those witnesses in here.
Okay.
I just don't. Who did you want to have testify here, Mr. McCurry?
Well, I don't know, I necessarily want anybody to testify, but I suppose we could call Ms. Ducal if the court wanted to hear from her relative to, you know, she did hedge her bet at the end, I believe.
Well, you asked that the witnesses be sequestered. I'm just wondering who you wanted me to call, bring up for you, whatever you wanted me to do.
Well, and again, this is how we're getting approaching the realm of, you know, burdens of proof and discharges of saying. I don't know who's.
You let me worry about that.
Okay. But
I could have done one of two things, just so this record is clear. I did not have to afford him a hearing immediately. I did not want to wait till Tuesday. The Wayne County Prosecutor's Office is so incredibly overstaffed, they could not have sent me anybody unless I made jurors wait in the juror assembly room tomorrow, because it just so happens Mr. Kazak will be here.
Well,
I was trying to get to the bottom of this as quickly as I could, so I could make a decision as to whether or not there was a violation of the bond without having to have him sit in jail for 5 days. So I just need this to be clear.
Judge, I respect that. And
Okay.
I'm with you, and I thank you.
Okay, so you asked when Ms. Duco,
I mean, I suppose in light of the testimony, we can ask her, we call her to the stand and ask her how sure she is about the voice that she claims she heard. Because I believe at the end, she hedged a bet of it and said, I believe so.
but she was, hang on, but you asked, I just want to make sure we're on the same page. You asked when she was testifying that the victim's advocate, that both of them leave, right? That's what you asked. You asked to sequester witnesses. Ms. Duco was already on the stand.
Correct.
So did you want to call one of them?
Well,
If you don't, you don't.
we could call Anna Duco to the stand, but then that would have Kayla Duco be sequestered.
Okay, is that what you want? I want your client.
Yeah, I think if we're gonna get to the bottom of what
Come on up
did or
here.
did not happen at 140.
Ms. Duco, Kayla, why don't you have a seat out there, please?
Would you like me, Your Honor?
Come on right up here to the witness chair, please. I'm going to ask you to raise your right hand. You solemnly swear or affirm under penalties of perjury the testimony you will give in these proceedings will be the whole true self you got.
Yes.
Can you have a seat and spell your complete name for me?
My name is Anna. Last name is Gardner. Now I got married last year, so it's Gardner.
And
First
what was your
name
maiden name?
Duplo. Duclo.
And so Kayla is what relation?
She's my cousin.
All right. Were you were initially in here
Yes.
when Anna testified that there was a phone call received sometime around 1:40 or 1:46 this afternoon
Yes, sir.
from a phone number 508-2766. Were you not?
Yes, I answered the call.
And why did you answer the call?
The phone was next to me. She was talking with Rachel and going over stuff, and it started ringing, and I said, should I answer it? Because it was a number we did not know. And you have to put that phone on speaker. So I answered it and hit the speaker button. Because if you hold it to your ear, you can't hear anything. That speaker on top is broken. So I hit answer and hit speaker. It was on the table in front of everyone. And it was like you heard chatter for a second and then leave. And then it hung up.
Do you know Mr. Crane?
I know him, not like close with him, but I know him. He's been in my house. I've been in his house. He's been with my cousin for years. So yes.
Okay. And do you recognize his voice?
Yes.
Can you identify who the caller was?
It did sound like him, yes. Of course, I can't say 100% because it was not his phone number, but it did sound like him. And nobody has called that phone except for the text she got from him and the dentist office and the courts. So I answered it because I wasn't sure if it was going to be someone from a police station because she was called from the police station that we had to come here today. So that's why I answered.
Do you have any questions of her?
I do. You indicated that there was chatter for a second?
Yeah, it was like you just heard like a background noise, like just noise in the background when you answer a call. Like it wasn't dead silent in the background. And then you heard leave and then it clicked.
Chatter in the sense of people talking in the background?
I don't know if it was people talking. It was just noise. I guess chatter was the wrong word, but just like noise in the background for a split second. I said hello. Noise in the background, and then all you heard was leave, and then the phone
You said
hung up.
hello.
Yes, I said hello
Okay.
when I answered the phone call.
So it wasn't, Anna didn't take control?
I am Anna, yes.
I'm sorry. Kayla didn't take control of the phone?
No.
Once you answered?
Correct. It was just on the center of the table
Okay.
on speakerphone.
And would it surprise you to learn that Kayla didn't mention anything about chatter or any other noise besides leave?
No, it would not surprise me. She's been very flustered these last couple of weeks, so.
All right. Do you know where Mr. Crane was this afternoon at 1:40?
I do not know.
Okay, you came here with Kayla or no?
Yes, I drove her here.
Okay, and when you got here, did you see Mr. Crane's mother's vehicle?
It was not here yet. It pulled in as we were walking in the door.
Okay, so you did see Mr. Crane pull in?
I saw his mother's vehicle, if that's who he was with, yes.
Okay, what time was that?
I'm not sure.
Okay, thank you.
We got here at about 1:30, I think it was about then.
Okay, you don't know when I got here.
No, I do not.
Nothing further to it.
Is there anything you would like me to ask him, Sergeant? Ask her?
I don't think so, Your Honor.
Ma'am, thank you very much. You could step down. I'd like you to do me a favor and send Kayla back in.
Yes, sir.
Can you step up here for one more minute, please? Yes, ma'am. And you are still under oath, okay? The phone that you have now, when did you acquire that phone?
Which one? The one that I'm
The one
using?
that you were called on this afternoon?
We're on the same plan. We got it maybe 3 years ago. I've had that number for maybe 3 years now.
Okay, I thought you said something to the effect, the only one that's called you was, I think you said the court and your dentist. Didn't you say your dentist?
Yeah, no one's been calling me. I've been by myself. I haven't,
Did you see Mr. Crane on your way into the courthouse today?
as I was walking in, he pulled in his mom's Jeep. Like he was pulling in right as I was walking in.
How long have you two been together?
Would be almost 5 years.
And you said, Ms. McCarty is correct, you did say, I believe it was his voice.
Yes,
I don't know what that means. I want to be sure. Are you certain, 100% certain?
just the tone, the way it was said to me. Like I believe it was him. Just the way it was said, the tone in the voice, the sound.
Do you have any other questions?
What did you hear before leave?
It was just leave
Nothing else?
and then hung up.
Anything else?
No, you don't have.
You can step down.
I can.
Do you have any other witnesses that you want to present? Any other witnesses you want me to make come up here and testify?
Well, to the extent necessary, I'd like this detective to look at the surveillance camera, unless you want to take judicial notice of the fact that we were in my car at the time in which this call was allegedly made to this witness. I think a follow-up in that regard would be do a dump of the witness's phone to determine who called her, when, and on what frequency. If she's had that phone for 3 years, the testimony this afternoon, and nobody calls her but the court and the dentist, and I think that stretches the bounds of credulity. I mean, the upshot of this, Judge,
I'm really concerned about this at this point.
yeah, I am too.
Hang on,
The upshot of what
hang on, let me finish. Anybody who was listening to me on Tuesday, well, I never really said I find that there's a bond violation. Anybody who was listening to me would have known, or I did a horrible job of explaining myself. But there was no doubt in my mind but that Mr. Crane had contact purposely. I wanted to give him the benefit of the doubt. I did not want to revoke the release. I did not want to forfeit the bond. I don't know that I used the word that you used in court or about anybody who was listening. But I do know that I made it abundantly clear I wanted there to be no contact. To say that I was shocked this morning when I'm receiving this testimony. And now, so what I'm left with, Mr. McCarty, is two things. I'm left with somebody now telling me that they texted her accidentally. Which I can't imagine doing after a judge just talked to me 8 hours early. And that somehow, some way, somebody called right when she's in court and said, leave. It was neither Mr. Crane nor anybody else affiliated with Mr. Crane. I'm 64 years old. I don't know how long I've had a cell phone now, but I don't ever remember just having somebody call me up, say, leave, and then hang up. And how ironic it happened when somebody is in a courthouse. Now, Mr. Crane, I found to be very unbelievable the other day. I really did. He pushed all the buttons. He pushed all the buttons of what I've learned in my career here as to why and how people lie or how I can detect liars. So somehow, some way, within 4 or 5 minutes of the time that she's supposed to come in, maybe 10, I think I initially told everybody to be here at 2, but I don't remember. Or 15 minutes while in a courthouse, while within a few minutes of driving through the parking lot into the courthouse and sitting in the courthouse, I either have to be that she's totally contrived the story, which has been corroborated by her cousin to the tune that somebody called and said leave, or suddenly, somehow, some way, somebody called and said leave, even though she probably has never received such a call. At least I have. At a very crucial time when everybody knew that I was summoning everybody for a bond violation. I would have thought, I don't want to know what he told you, that's attorney-client privilege, but I would have thought if I violated a no contact provision that a judge said, and I can't imagine doing that accidentally, that I would have called my lawyer. In other words, his defense seems to be he was intending to text somebody else and accidentally texted this young man.
And tried to unsend it. Thought he did.
And then somehow, some way, she gets this call leave while she happens to be in the courthouse from the phone.
And Mr. Crane.
So I'm going to let you argue, but I'm not directing this detective to do any investigation. If you want to do that, you can do that. If you want to ask them to get the surveillance video, you can feel free to do that. But I'm going to make this decision now. I think it's that important, that serious, that when somebody was told not to have contact, did have contact, the judge chastised them for 5 minutes. And 10 hours later, he's going out and having contact. And then so incredibly, she gets this call leave right when she's in the courthouse to testify regarding the bond violation. Now, I grant you don't have a smoking gun where there's 20 witnesses watching somebody pull a trigger. But if that isn't circumstantial evidence that he committed a violation of the no contact provision intentionally, I don't know what is. So I'm going to listen to your argument, and I'm going to make up my mind. But he scares me. Put your hand
Sorry.
down.
Sorry, sir. Sorry, sir.
You know, I've been doing this a long time. I've seen every type of person come in here and try to tell me things that just aren't true. Now, I thought I was pretty good at determining who was a liar before I got here. And I got to tell you, you cannot sit and listen to 250,000 cases over the course of 29 years and not become exceedingly good at it. It's almost impossible. So just let your lawyer do his job. So that's what you've got to contend with. This is not personal with you, Mr. McCarty. It's your client. Your client. Your client is not listening to instructions from judges. And this is not personal. I mean, I love it when people say your court. Nobody's ever here. Never one time in 29 years have I sat here and said MYCOURT, not once. Nobody's ever heard me say that because it isn't mine. I don't see a deed on the wall. Nobody's gifted me, willed this, and this is not about me. I just happen to be this guy that somebody trusted 29 years ago, and people continue to trust to sit here. This is about our system, though. And I'm not going to put up with people that think they can make their own rules. So you got a lot to argue and contend with here because I'm not changing my bond unless you do some real fast talking here. I'll listen to whatever you have to say.
Well, certainly my intent is not to talk fast or slow or anywhere in between, but to try to arrive at the truth and justice here.
Of course.
And the truth of the matter is, my client sent a text to Kayla at 6:06 p.m. on Tuesday, the day we were in court. Now, another truth is, if you look at that phone and do a forensic dump that I've offered, and I'll consent to a release of it this moment while he's in custody or anywhere in between, that he attempted to unsend that and thought he had done it. Otherwise, he might have called me and said, hey, I just screwed up. But he didn't. What he did do is after he sent an unintended or a text to an unintended recipient, he immediately then turned around at 6:08 and texted his daughter. And then again at 6:11, and not hearing from her, texted his mother. Now, what he's now establishing like an alibi for this. He's establishing a defense when he gets called into court on a bond violation. Oh, I've got it all figured out. I'll show him this is why I did it. That's preposterous. The man plows snow for a living, but he's sophisticated enough to use some robocall as he's sitting in my vehicle. As we're told about a hearing about an hour and a half ago, he put it all together and figured out how to do a robocall and called this complainant and said, leave. How was that even possible?
I didn't say he did it.
Well,
I did not. If you listen to me carefully, I said him or somebody else.
Well, okay, but they didn't say somebody else's voice. They said it was his. And this witness sat up there and told you on the basis of one word. And while she hesitated to say she can't be completely certain, I believe it's him. Now, Judge, we didn't even find out about this until later this morning.
Well, no.
And right, and so, but you have to understand. So, how is it that he established this timeline of text back at 6:08 and 6:11, and then 6:15 with his mother, thinking that this was going to come up? I mean, that's like creating the alibi, before the crime is even reported. This doesn't make any sense, Judge. It just doesn't.
So all these were just a mistake. It's your
No, absolutely. Hey, Judge, the other day I went to text an opposing counsel, Chris, and sent her a copy of the Michigan Bad Government regarding surrendering of your license. And you know who I sent it to? Chris Creighton, my son's head football coach at Eastern Michigan. Now that was embarrassing. That I sent a private communication between me and opposing counsel, Chris Anderson, and I sent it to the head football coach at Eastern Michigan. And I'm a lawyer, and I'm here to tell you I make mistakes.
Of course.
And so he's got 3 Ks in his life: Kayla, Kristen, Kylie, and he sent it to the wrong one. And as soon as he realized it, he tried to undo it and thought he did, and then he went and took care of what he tried to do, his business, so to speak. Now, and that's all in that phone, and it could be analyzed and be discovered. I'm not trying to hide anything.
You can feel free to have it
Okay,
analyzed.
but Judge,
I'm
this
not
whole.
ordering them to, and the court's not about to undertake that.
Okay, I appreciate that. But what I'm suggesting is to entertain the possibility that this was unintended. And he did it, but he didn't mean to do it. And it doesn't make any sense, not having any contact since January 22nd. All of a sudden, you read him the riot act, the come to Jesus speech on Tuesday, and then he's gonna text her, "What you doing?"
Well, he did have contact with her since the nature of the hearing happened. That was contact since January 22nd.
Well, to the extent
I'm
you're
talking
on.
about the contact that had occurred that I heard about on Tuesday, which was what, the 14th?
Tuesday was the 14th, and I
And
think
I
it was
believe
the
the
week.
contact, now listen, you probably, I'm sure you're busy, but I probably only had 100 people in front of me since he was in here Tuesday, if not more. But my recollection is that the contact had happened the day before. That
No,
was my
it was the week before.
week. Okay, well,
That's
so that's not truthful when you're saying that he didn't have any contact with her from January 23 until the night of the 14th.
Let me clarify that and specify. He didn't have any phone call, text conversation with her since, it's frankly, like the majority of us how we communicate. And to me, it doesn't make any sense how he would go from January to 22nd to Tuesday, the 14th.
I know a lot of this doesn't make
Well,
sense every day,
I know, but
every single day.
I think
No, I agree with you. A lot of it doesn't make any sense.
Right. But it further doesn't make sense that my client is somehow sophisticated enough to create a defense to a violation of probation that's not even been, asserted yet. And we don't even know about it until this morning. And then somehow, between getting off of work and having his mother give him a ride here and me coming down from Howell, he's sophisticated enough again to create this robocall and a message of
Court's convinced. Did I let you finish?
Hey, Judge, I'm not going to stop the train.
I
get
know.
it.
I'm just asking if I let you finish. The court is convinced somebody called and said leave. The testimony was that the belief was that it was the defendant. I told the defendant not to have contact. He was told that by my co-judge here, my colleague who set the bond, I believe, initially, not to have contact. He had contact last week. I admonished him on Tuesday. I didn't forfeit his bond. I didn't revoke the release. And I'm just convinced he had contact, not on one, but on 2 occasions, now 3, if you include the one last week. The bond's forfeited. I won't set 10,000 cash. It is going to be 4,000 cash. Do it again, and we're going to have a big problem. Take her out of your phone. Do whatever you got to do. 4,000 cash. Bond conditions otherwise continued. I will see everybody here. Counsel, I signed your order.
Yeah, thank you.
You have a funeral. I understand. I'm sorry for your loss. We're going to do it March the 7th at 10, but you can't ask me for another adjournment, okay?